Thomas Gaume.
Thank you, Thomas Gaume, and happy Independence Day. And in the name of independence, freedom, liberty, effective immediately, I withdraw any implied consent for the collection, storage, or querying of the location data of my personal property or myself. I demand that the City of Palm Bay cease tracking my movements through the Flock Safety Network. I make this statement because on Monday, the legal landscape in this country changed. The U.S. Supreme Court ruled 6-3 in Chatrie versus United States that the government collection of digital location data is a Fourth Amendment search. And as Justice Keegan, writing for the majority, rejected the third-party doctrine, ruling that citizens do not consent to location tracking simply by operating on public roads or using digital networks. I would add to that, or visiting city parks. In his concurring opinion, Justin Gorsuch went further, defining digital location history records as personal property protected as an in effect under the original text of the Fourth Amendment. What that means is all the location data you've collected on me over the last 5 years with Flock cameras belongs to me, not the city, not Flock. I want it back. I don't want you to have it. Under Chatrie, the collection of data itself is the search. The warrantless compilation of innocent citizens' movements over 30 days is a constitutional violation from the moment the first image is taken. You cannot cure an unconstitutional mass dragnet by requiring a warrant to search it after the fact. The 30 days of historical location data you currently hold was gathered without warrants. Under Chatrie, that database is a compiled record of unconstitutional searches. Holding it is a contentious daily violation of our Fourth Amendment rights. If this administration is unable or unwilling to comply with my personal constitutional demand to cease warrantlessly tracking myself or my property, and any retention of any identifying data points, you must suspend operations of the Flock network if you cannot comply with my request. Thank you.
Thank you. Madam Attorney, are you tracking that, as far as I was tracking geofencing, the Supreme Court ruling, are you tracking and able to brief a little bit regarding that?
Yes, Your Honor. Mayor. Force of habit. I know a lot of people are hearing this, but to give them some background on what the case was about as far as the U.S. Supreme Court case and what they actually held and what the background was. Essentially, Chatrie involved, there was a bank robbery. So the person robbed the bank, got away, police had no suspects. So what they did was they did this, it was a 3-part process in which they contacted Google to find out geofence information. So they created an area outside of the bank for a certain period of time and told Google, they did get a warrant, provide us all the numbers within that area. Then they took that from that level, they got it down to another time frame, another search, and another. And after they did it 3 times, because they were just getting numbers then, they were able to get down to 3 persons, one of which was Mr. Chatrie. They were able to then arrest him, hey, you're the suspect, and he filed a motion to suppress. So what the court was dealing with was whether, when the officers obtained the information from Google, was that a search? And it was, this information is based upon his phone. So what the court did, they looked at a case that they had already ruled on, and they extended it. The case was Carpenter versus United States. And in that case, the Supreme Court held that if police were to get information about essentially the cell phone towers from a third party, that they needed a warrant. And they said getting this historical information and this location are pretty much the same. So they extended Carpenter. And it's important for you to realize they extended Carpenter, because after Carpenter, there were lots of people that challenged the license plate reader. Well, if they said under Carpenter, you can't get the information about historical information from cell phones, you can't do license plates. And all the cases that tried to use Carpenter to invalidate the license plate readers, they were not successful. This case has nothing to do with license plate readers. What it has to do is geofencing, and it talks about essentially what is moving further. It's everybody has cell phones. So if you're getting information about somebody's cell phone, you're going to have to get a warrant. That's essentially what it is, further extending that the cell phones, they're everywhere, everybody has them, there are many computers. You're not going to get information about that people have about cell phones without a warrant. That's what the case is about.
Thank you, ma'am. I appreciate the brief and highlighting that. Next speaker.